From distant lands we gather, hearts of fire all along. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big because we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Yeah. Oh, I have a few different intros. I know YouTube says it's good with consistency. I have the same one because people will recognize it. I get kind of bored. So I have a few different intros, which I change in between depending on the mood I'm on, the topic I'm covering. But hey, this is the Dan Markel murder was a number of years ago. There has been a number of trials already. First one, the two hitmen were convicted. Then the middle person was convicted, Katie whatever her last name was. And then last time it was Charlie Adelson who bit the dust. And now it is the matriarch of the Adelson family, Donna Adelson, who is charged with first-degree murder, as they will claim the orchestrator. She is the one that more or less involved the entire family in, we need to end Don Markel because Wendy doesn't want to live in Tallahassee. Yeah, it's that stupid. Wendy and Dan divorced, a very nasty divorce. And since joint custody, the kids had to be somewhat close near Tallahassee. But Wendy wanted to live in Miami. And the Adelson family couldn't have that. So instead of working it out, Donna decided, allegedly, Dan Markel needs to die. So that is the premises of this. But today is the final pre-trial hearing, where everything should be solved before trial starts in a couple of weeks. I got home early today. Screw you, Dave. I've been working as a maniac all week so I can get home earlier on Fridays. I am supposed to be napping now because at noon I have another stream. And 5 p.m. I have another stream. I woke up 4:30 a.m. this morning. So this might be, when we get to Slightly Buzzed Friday Law Show, I might be very, very easy to get buzzed. But we are here with Adelson, the matriarch, Donna Adelson, final pre-trial hearing. Let's go. Okay, Law and Crime is having... What? Hold on. Is Law and Crime spoofing out of Deep Dive True Crime? That's kind of funny. Okay. She seems to be in an unfortunate good mood. I don't know why. That is a woman whose time in jail has not been kind to her, because now every cosmetic surgery...
All right, court is now session. The Honorable Judge Stephen Everett presiding.
Morning, you see it?
Hi, Judge.
That is a good judge, in my opinion. All right, cat avatar. I'm not good enough. Should I have this one? And do this? No, hold on. All right, Josh, get going. Chop, chop. Yeah, she's very, very dislikable. One of the things she did during the custody battle between Wendy and Dan was to propose to Wendy to dress up the kids in Austrian painter trying to be a world ruler Jugend uniforms, just to spite Dan Markel. They are both Jewish families.
Here this morning in State versus Donna Adelson, 2023 CF 3226. For the final pretrial hearing this morning, we're going to address all of the outstanding motions and also some matters pertaining to the trial, which is still scheduled for the selection of the jury starting on August 19th. The parties can make their appearances for the record.
Georgia Kappelman for the state.
Jackie Fulford for Mrs. Adelson.
Joshua Zellman for Mrs. Adelson.
I believe we have several defense motions to address. Ms. Kappelman, the state has not filed any additional motions in limine that have not already been addressed by the court.
That's correct, Your Honor.
Right. Let's start then with the motion in limine concerning the court file relating to the dissolution of marriage. Mr. Zellman.
Thank you, Your Honor. Your Honor, as is my custom, I lay it out in the motion. It's our position that the vast majority of the court file, even with the court taking judicial notice, is inadmissible. It's irrelevant. Paragraph 7 of my motion provides a somewhat comprehensive list of the items that are in there that have no bearing, have no relevance, they're not material in any way to this case. And so we're asking that, aside from very limited number of items that the state can establish has relevance, and it's not barred by hearsay, we're asking the court exclude that
They
file.
tried that with Charlie.
Kappelman, which parts of this file is the state seeking to admit as a part of its case in chief?
The entirety.
Right. As to the items that deal with, as identified in paragraph 7 of the motion, what exactly would be the relevance first? And what is your argument as the hearsay?
For relevance, Judge, it goes to the motive, the level of intensity of this litigation, the volume of the paperwork suggests that it was very litigious and went on for some time. The words that are used are strong, even hateful, and this was a cause that was adopted by the defendant, as the emails evidence will show. So it's important for the jury to understand the foundation of this motive is this litigation that began with the divorce, continued beyond the divorce with the child custody issues that developed later.
All right. So in part, the volume of what occurred over the divorce proceedings, you want the jury to recognize this goes to motive in some way.
Yes, Your Honor. In reference to hearsay, the items are not being offered for the truth of the matter asserted. There obviously was a litigious divorce, but it's being offered to show the effect on Ms. Adelson. These items were shared with her. The evidence intends to show she was very involved in the pleadings. She was sent the pleadings and offered detailed responses for how Mrs. Wendy Adelson should respond to the pleadings. So it's very bound up in the state's theory of the motive for the case.
All right. Mr. Zellman, as to your client's emails to her daughter as this litigation was going on, are these contested in any way?
With respect to the initial dissolution proceeding, no. However, in reviewing the emails, the post-dissolution matters that were filed by Mr. Markel, there's no evidence in those emails that those pleadings were shared with Mrs. Adelson. And so certainly, if the state's theory is that it goes to the motive, and that's the way of getting around hearsay, they have to establish that the pleadings were sent to her. My review of the emails show that did not happen. So they can't go to show my client's motive if she didn't receive that.
All right. As to any pleadings that correspond with emails or communications that were made by the defendant and otherwise demonstrate her role in or some part in the divorce case, as to those, I'm going to rule they are admissible.
Yeah.
The pleadings themselves, if they're being offered not for the truth of the matter asserted, but to otherwise demonstrate motive or intent, those are admissible. However, Ms. Kappelman, as to the bulk of the file itself, I do believe the defense is raising a clear point on this. Absent a connection or a nexus between the defendant and specific aspects of the divorce file, what is your argument concerning it?
I mean, there are pleadings in there that are not necessary to show the motive, but I did offer the exhibit itself in its entirety to demonstrate the bulk. If Your Honor is not inclined to allow those pieces of paper that cannot be directly connected to the defendant, may I be permitted to show the exhibit as a demonstrative to the witness to verify that that is the entirety of the divorce file?
It is permitted as a demonstrative. You may also ask questions that generally deal with the amount of filings and also the volume of the case, but ultimately as to responses for production or mediator notices, I'm inclined to agree with the defense as to that point. If there's not either a relevant connection or a nexus between the defendant's actions and then what occurred in the dissolution of marriage case, all of it does not come in as substantive evidence. But I do want to make clear on this point, Mr. Zellman, as to what the witnesses will testify to, and none of us will know this until the evidence actually begins. This file can be used for purposes of impeachment, and it can also be used for purposes of rebuttal. Depending on what the witnesses say, what might be not a part of the state's case in chief may still be available to them through other means are permitted by the rules of evidence. Is everyone clear on those?
Yes, sir.
Yes, Your Honor.
Okay, yeah, that's a semi-win for the defense, because in the trial against Charlie, there was a bunch of things from the divorce
Let's move on to the
and the
motion
custody
limiting
battle that was
concerning the
admitted.
testimony of Sarah Youssef. Mr. Zellman,
Again, Your Honor, we stand on the motion.
Ms. Kaplan, in response.
I would just ask Your Honor to reserve on her. The state has no intention of calling her, so I don't think, unless that changes, that there's any reason to address her testimony at this time.
Well, and I assume you are going to leave Ms. Youssef available as a rebuttal witness if necessary.
Yes.
If a witness is not going to be called, it essentially moots the issue. On that point, Mr. Zellman, the state is not committing to calling this witness. If they do call them at that time, I will issue a ruling concerning your motion in limine.
Yes, sir.
As to any purpose of rebuttal, ultimately what comes out as a part of the defense case, Ms. Youssef still is able to testify in that capacity.
Yeah. Wendy and husband Adelson tried to flee to Vietnam after Charlie was convicted.
Does the defense have any argument that has not already been made through the pleading?
No, Your Honor.
Ms. Kaplan, in response.
Judge, I agree with some of the defendant's motions. I don't think Mr. Webster can offer opinions. For example, his testimony, of course, will be governed by the same rules of evidence that every other witness is governed by, but he does offer some relevant points. So I think I should be permitted to, I don't know, these motions kind of blow my mind, because it's like we want to pre-litigate every statement, including potentially objectionable statements that can be addressed during the trial by a proper timely objection. So I would ask that it be handled in that way.
All right, concerning the testimony of Mr. Webster, Mr. Webster, in his capacity of representing the deceased, certainly can testify factually as to what his involvement was with the divorce case. And also, he may testify concerning the nature of the proceedings as to any opinions that go beyond that. Ultimately, I think that's where we are going to have to get into what is being asked and what would be the response that ultimately the defense would find objectionable. But generally, as to any opinion that Mr. Webster cannot give without a proper foundation, I think it's settled as a matter of evidence that no witness gets to generally opine on matters in which they are not qualified to testify to.
Yes, I misspoke. I meant to say Donna and Harvey tried to flee to Vietnam. Who doesn't have an extradition treaty with the United States? The detectives caught them trying to board the plane. And in a prior hearing, Donna tried to argue, oh, we were just going on vacation. They bought one-way tickets. So, yeah.
Is any other ruling being sought concerning Mr. Webster beyond that by the defense?
Well, yes, Your Honor. In prior trials and in deposition, Mr. Webster testified about statements made to him by Mr. Markel. Those are hearsay. There's not an exception. Those statements weren't shared with anyone else, certainly not my client. Those were statements that were made during the meeting in May of 2014 that Mr. Webster. There's no exception that I'm aware of under the hearsay rule.
This is from the stream. I'm not controlling the sound.
Statements made by the deceased to Mr. Webster. Ms. Kaplan, do you have an argument?
I think I agree in general that those statements would be hearsay. I don't recall what my theory of admissibility was in prior trials, but I would agree to approach if I intend to elicit a statement made by Mr. Markel to his attorney and offer my theory of admissibility prior to asking the question if I decide to do that in this trial. I don't think I plan to do that, so it's hard for me to address what that theory might be now.
Well, again, as a general principle of evidence, hearsay that has no exception is not admissible. If the state is seeking to admit this statement for a proper purpose that actually has a basis in the rules of evidence to be admitted, you will need to approach so that way the information is not placed improperly before the jury. The motion in limine is granted as to Mr. Webster offering any opinions for which he is not qualified to give. The court will reserve the ruling on the issue of any statements that he may testify to by the deceased. If the state, again, will have to present an actual exception to hearsay in which the matter can be placed before the jury.
I totally.
The renewed motion in limine concerning the Latin kings. Mr. Zellman?
Yes, Your Honor, this goes in part to the theory of the defense and why Mrs. Adelson acted the way she did, the language that she used on the 2016 wire calls. Typically, I know that we would want to have the foundation paid through her testimony for that, but if the court were to bind our hands in questioning the state's witnesses, it would be too late to wait until she testifies. We would lose the ability to cross the state's witnesses on that issue. It's very limited. You have Luis Rivera. There will only be a few questions at most. Potentially Charlie Adelson, depending on when the state calls him. Certainly special agents, I believe it's Jimenez.
Now, in the last trial, he outright testified that he was, I guess, at least pretending or trying to influence your client as a member of the Latin Kings gang.
Yes, sir.
All right. To that end, Ms. Copperman, what is your argument?
Same as my argument has always been on this issue, Judge, which is that Rivera was a gang member. That's why he was recruited to do this. I think that's relevant. But the fact that he was a leader of a specific gang, I think is just bad character evidence that doesn't lend anything additional, more prejudicial than probative, and I would ask to exclude those details.
Similar to what we had in the last trial, as to this painting the character of Mr. Rivera specifically in a negative light, the court's ruling will remain the same. As to the witnesses, though, Mr. Jimenez or other witnesses that may present this topic unsolicited on their directs, once the horse is out of the barn, it's out of the barn. As far as any cross-examination of Mr. Rivera specifically, the defense may cross-examine Mr. Rivera as to his role as a gang member and why he was recruited into this matter to specifically serve a purpose as it relates to the conspiracy of the killing of Dan Markel. Now, with regard to undercover or the former undercover agent, Ms. Cotterman, this is where I believe the analysis begins to diverge on this topic. He specifically approached the defendant as a Latin King member, correct?
No, sir. My recollection is, I know that was his testimony, but I would instruct him not to say Latin King in the future. However, he didn't say anything to Ms. Adelson about being a Latin King. I guess that was his version of acting like a gang member. I don't know how well he did. Ms. Adelson didn't seem to think he did very well, but that was the intention. He did not represent himself to her verbally as a Latin King gang member. He was not wearing any clothing or other signifiers that he was a member of a specific gang. I think the idea was just, you're an associate of this killer who is a gang member.
In response on that topic, Mr. Zeldin.
Just looking at his previous testimony. My role, I'll quote from page 1067 of the trial transcript, Mr. Charlie Adelson's case.
Yeah.
Starting at line 20, question, can you explain what that operation was? Answer, my role in the operation, I was portraying a Latin King gang member and I was instructed to conduct the bomb. Continuing on 1068, question is, all right, when you say you were posing as a Latin King gang member, did you announce yourself as a Latin King gang member to the person you approached? I did not. Okay. So that's the role. That was my role. You're in character. That is correct. That is his testimony. And, I believe that once, especially with the call that my client made to the undercover on May 6th of 2014, when he became verbally aggressive towards my client, that factors into his role as a Latin King gang member. And I know in the previous hearing last year, Your Honor questioned whether there was a difference between a Latin King gang member and simply a gang member. The answer is absolutely. In Miami, in South Florida, there is absolutely a difference between a gang member and a Latin King gang member.
Even with that being said, this ultimately goes to your client's state of mind, who is going to establish how she knows the difference between, forgive the pun, the garden variety gang member and a specific gang member.
I think between her testimony and anticipated testimony of Charlie Adelson.
As to the questioning of the former undercover officer or special agent Jimenez, I will permit the defense to question the former special agent as to whether he was portraying a member of a specific gang as a part of his own operation. Depending on what the answer is, we will revisit the issue of whether the name Latin Kings needs to be specifically uttered as to either Mrs. Adelson or Charlie Adelson testifying concerning her state of mind and knowledge of the Latin Kings. As it goes to state of mind, the defense may certainly inquire as to that during the defense case in chief. As to Luis Rivera, the court's ruling will remain the same as to his leadership role or specific affiliation. The fact that he is a gang member may be inquired into, and the fact that he has had, or the fact that he had, or his role while he was recruited in this case, that certainly is ripe for cross-examination and may be inquired into. But as to him being a specific Latin king, that is where the line is going to be drawn. Do we need clarification on these rulings?
Just one, Your Honor.
Not from the state judge.
Okay, I would count that as a win for the defense as well. I can't do anything about the sound other than make it louder. But I don't think that is the main issue with the
concern
audio here.
We have, Your Honor, is that Mrs. Adelson, part of her state of mind, her level of fear, is that it's not just that she learned he was Latin King, but that he was the leader of one of the branches of the Latin Kings in South Florida. That heightened her fear. And of course, she will testify to that.
I cannot make her testify. If she is committed to do so as a part of her defense, that's her choice. But ultimately, someone with competent knowledge has to testify to this fact. Eliciting information about state of mind from the witness that either has not spoken to your client or either has no knowledge of the state of mind, I'm not sure how that can be accomplished other than either your client herself, her son, or someone else who has direct knowledge of her state of mind at the time, unless you have an argument.
So I guess the way that we could accomplish that, Your Honor, is that Mr. Rivera, he is under a defense subpoena. We would ask that he remain for the defense case so that we can call him on our case in chief.
That's fine. Mr. Rivera, as I recall, never had any direct communication with your client, but this is to elicit another relevant matter.
That's correct, Your Honor. It would be, once we establish the foundation, I would want to recall him for the specific purpose of him confirming that he was a leader of the Latin Kings.
Very well. Mr. Rivera will remain under the defense's subpoena until the conclusion of the trial. Let's move on to the defendant's motion of limine as to the interpretation of emails, recorded phone calls, and text messages. Which witnesses is the defense referring to concerning this motion?
I think it goes really to retired Detective Isom, Special Agent Sanford, potentially Jason Newland. I think a number of witnesses have offered interpretation of statements that were made. Now, we're not talking about coded language. Coded language is treated different. What we're talking about is the emails, the recorded phone calls, and the text messages, other than coded language. What we're asking the court, because it has come out so frequently, that the court prohibit the state and, what's good for the goose is good for the gander, the defense, from asking someone other than an expert to offer an opinion about what someone means by an email, what they meant by a statement, or what they meant in a text message, aside from the language that's used itself.
Ms. Government, response?
I agree, that would not be admissible.
The motion in the limine is granted as previously raised.
Okay,
in the
this
argument
is
on
interesting
matter,
because
in matters that would go to a code in which a
in prior trials, a bunch of these things were either allowed or the witnesses blurted out. So I must say that Donna's new set of attorneys does a better job than the previous attorneys, who were also Charlie's attorneys. For you who don't know, that set of attorneys were disqualified from the case after over a year in pre-trial motions and hearings. The judge asked them, "We need your Charlie's written consent of you also defending Donna," because they represented to the court that he had. It turns out he hadn't given written permission to his lawyers to also represent Donna. This judge was not happy about that.
witness could lay a proper foundation on this issue. Certainly, they may testify as to that point, but any general opining as to what an email, a phone call, or a text message means will not be permitted unless there is a proper foundation that can be laid by that witness. Next, the defendant's renewed motion in limine concerning travel as consciousness of guilt.
Your Honor, I know that the court previously ruled on this issue and that allowed the state to use this information in their argument. The new information, as I've laid out in paragraphs 4, 5, 6, and 7, I stand on the motion. Those additional pieces of information had not previously been provided in the court, and I think that it's significant because it goes to her state of mind for making the travel plans and for going to the airport and for stepping on the jet.
So I'm recalling prior counsel's argument correctly. Mr. Rashbaum did raise the fact that there was no legal process, subpoena, or warrant for your client, correct?
I believe that's correct.
So, response, Ms. Kaufman?
Judge, I don't think this is new information. This was never disputed. I don't think it changes the analysis.
On this particular point, the court has reviewed the transcripts of the depositions that were cited by the renewed motion, and the ruling will remain the same on this issue as before. These matters go to the weight of the evidence and not the admissibility. The jury, as the trier of fact, is going to decide what significance to give to the evidence. The defense also is free to cross-examine on all issues that pertain to Mrs. Adelson being free to travel. The matters that have been previously raised within the motion to suppress and rule on as to the phone calls and other evidence, that also will be presented to the jury as well. They will make up their mind.
Thank you, sir.
Well, I believe that covers the defense motions. And Ms. Callahan, you stated that the state did not have an additional motion of remedies that not have been previously ruled on.
That's correct, Your Honor.
Judge, there's one additional one on the file of July 21st concerning the opinion testimony of Jason Miller and Patrick Sanford.
Oh, yes. Go ahead as to that motion.
Sorry, Your Honor. I'll stand on the motion.
Ms. Callahan, a response?
Judge, the defense elicited personal opinions of these witnesses at deposition about the lawyers and their ethics and how they think they might have been involved in the new investigation, and now seeks to suppress those opinions, which are clearly inadmissible. I don't understand it. I don't know why we're doing it. I would never elicit such a thing.
Well, Ms. Callahan, even though it might be inquired into in deposition, ultimately, if there's a basis to exclude it pre-trial, that's why it's being raised now.
Of course, there is no reason to elicit it at deposition, and it could never be admissible in a trial. So we're just wasting paper and time with these motions. No objection.
The state is conceding the issue. The motion
Oh.
is granted as to any opinions that would be offered by an investigator Newman or Special Agent Sanford. Again, there must be a proper foundation for them to offer an opinion on a subject. If they don't have the ability to do so, it cannot be presented as a part of the case in chief. I don't really see a context in which this might come around either in rebuttal or as far as impeachment, but again, these rulings are being made as to the state's, the substantive evidence the state may present as a part of its case in chief. If it needs to be readdressed as a matter of either impeachment or rebuttal, I'll take it up at the appropriate time. All right, let's go ahead and talk through some of the logistics for jury selection on 8/19. We are going to be in this courtroom once again. I believe the number of jurors that we have under summons right now, or prospective jurors under summons, I believe it's near 300. So what we're going to do on that Tuesday, essentially we will have the pre-screen of the jurors on the issue of pretrial publicity, similar to what we did in the last trial. The court will be asking these same questions, or substantially same questions. Both parties will have an opportunity to follow up on the court's questions on the issue of pretrial publicity. If a prospective juror is deemed suitable to return for a group voir dire, from there they will be given the date and time for which group voir dire will begin. For the pre-screening that will take place on both Tuesday morning, Tuesday afternoon, potentially Wednesday morning and Wednesday afternoon, I would anticipate by that point we would have a suitable pool of jurors from which, going through the pre-screening process, anyone who has had an issue or either the court believes, the state believes, or the defense believes is not suitable to go to the group voir dire. From there, each party will have an opportunity to make their objections known as to that prospective juror, and either they'll be told to return or they will be excused at that point. Does anyone have a question about the pre-screening process?
No, sir.
There you are.
Also, as well, so that we don't have any issues similar to what occurred in the previous trial, in which I believe there were allegations the jurors were speaking to each other. We are going to have additional bailiffs. The prospective jurors are going to be instructed not to speak to each other. It might make a long day for them, but they will be sitting in silence. We will provide reading material to them, and we'll have extra bailiffs on hand to ensure that no one is speaking to each other while they're waiting to be screened. Does anyone have anything they need to raise concerning those?
Is it your honor's intention to handle the pre-screening, I don't know what it's called, instructions that happen down in jury assembly?
Yes.
Okay.
I believe last time, I'm not sure if someone else qualified or not, but for each group that will be qualified, I will do it personally, so that way from beginning to end, they're seeing me, hearing me, and understanding. You're not to discuss the case or anything else with each other.
Perfect, that's the state's request.
Judge, how many of the 300 are coming each day?
Broken up into groups of 50, so 50 in the morning, 50 in the afternoon. We may not even need to get to the end of this grouping altogether if we are able to go through the pre-screening process on the issue of pretrial publicity. Once we have, say, 100 to 110, that's more than enough to get 12 people.
Oh,
How do you intend to handle proceeding once?
wow. In other cases, they had to collect 600, 700, 900 to collect a jury. This judge is 100.
we successfully select a jury?
Once we have selected a jury at that point, and also I believe too, we'll need at least 2 alternates unless the parties wish to have 3.
We defense would request for your honor.
Very well. Then once we have our 12 jurors and 3 alternates, at that point, we will swear them. If we have enough time to actually move into opening on that same day of the selection, we'll do that, so that way we can start to begin into witness testimony seamlessly without issue. How many days is the state anticipating to go through its case in chief?
I think best case scenario is 5, worst 7. So 6. I could see how it could run into the first part of the 7th day, Judge. I think 6 is a comfortable estimate.
Let me bring up my calendar. Assuming that we have a jury by Friday the 22nd, we know that in place August 25th through September 2nd as the state's case in chief. I think there is a holiday on September 1st, correct?
Yes.
Is anyone volunteering to work on Labor Day?
Jackie is.
I need one other hand. I'm related on that side of the table.
Thanks.
It is a holiday for the workers of the world, but we cannot forget that we have a trial to finish. All right, 8:25 through 9:02, then we're estimating as the state's case in chief. How long is the defense estimating to present any case that it wishes to do so?
Can I weigh in on that before they speak, Judge? We have historically picked a jury in 3 days at the longest. Twice we did it in 2 days. So my suggestion would be to start on Friday. We could even do openings as early as Thursday, if your honor was willing to entertain that. I know that's not the defense's request, but that would be the state's request, just to move it along as quickly as possible.
Well, for the openings only, does the defense have a position concerning this?
Judge, we don't want to make the openings unless we have a great deal of time after we pick the jury on a particular day. We would prefer to do the openings the next day.
So you're not asking to defer the opening to your case, you just don't want to open on the same day?
It's going to depend, Judge, on your ruling on the additional motion.
Right? On that matter, again, depending on where we're at time-wise, I would just instruct both parties to be prepared to potentially give their openings. I'm not going to place a time limit on the opening statements, but obviously, each party will be the captain of its own ship as to how you will captivate the jurors. Is either party expecting their opening to go beyond 30 minutes?
Depends on your ruling, Judge.
Ms. Calvin?
Yes, I think it could be up to 45 minutes. It's not going to be different than it was previously, but I'm sorry, I don't know how long it was. I would say 30 to 45 is comfortable range, Judge.
Right, as to the defense case, once we are finished with the state's case, how much time are you estimating?
It depends on your ruling, Judge, but anywhere between 4 and 6 days.
4 and 6 days. So that would place us then around the week of September 8th. Concerning any other matters that we can address as the logistics of the trial, I believe we will have rooms available for our family members, both for the victim's family and for the defendant. Do the parties anticipate making use of these rooms?
Yes, Your Honor.
Yes, sir.
All right. Please contact court administration. From there, you'll receive information as to how to access the rooms and when they will be made available.
Judge, can I clarify your intentions about when to start testimony?
Go ahead.
You intend to start testimony on the 25th, is that right? With the possibility of openings having already been conducted?
Well, at the latest, if we go into Friday with needing to select a jury,
Okay. If we get a jury,
if we get a jury prior to that Friday on, say, the 21st, really at that point, there's nothing preventing the testimony from getting started on the 22nd.
okay, so I'll be prepared to start testimony on the 22nd then, and my understanding was, and my subpoenas run through September 5th, but it sounds like we might be extending into the week of September 8th, is that right?
Which means that this trial will be done by the time I get to Miami.
That's what they said. All right, so we could potentially go through the week of the 8th.
If need be.
All right, I will attempt to get subpoenas out for rebuttal for that week, but I will advise the court that as of right now, those are not out.
We are losing a day because of September 1. But if need be, we can figure out logistically how to make this work for Saturday, continue working. I'm sure you all would like a break, but I'm here. Parties have any matters of logistics they need to raise concerning the trial.
Hey, Judge, we're going to have an issue regarding space. We're not all going to fit here. We also don't want our computer screens facing cameras and the audience being able to see what's on our computer screens. I have become very old, and the font size I use is very large. And probably someone in the back row can see what I have on my computer. So we're going to need to have, I understand we're blocked by this column,
Right.
but we're going to need to have some kind of setup where we can put our things and our defense not be disclosed ahead of time to the media and blogs and this and that. The second thing is
That would be
these
me.
microphones
You know how you do that?
have
Privacy
the ability that
screen.
You could touch it and it would turn off.
Mhm.
My client is hard of
Privacy
hearing,
screen.
so she talks loud. So everything she says is going to be picked up. This one is now set up so you have to press it each time you want to mute it. And, right, press and hold. You got to hold it down for it to continue to stay muted. And we're going to ask if the court admin could put it back to the function where we can push it off. I don't think there's going to be any opportunity in the trial for someone to not pick up on a recording of Mr. Zellman's voice. He's very loud. I tend to be loud too. So it's not going to be a record issue in our position, but it's certainly going to be a problem when we're trying to speak to our client about something because it's going to be heard.
Well, in front of the jury, but I understand the concern that we're registering with this. That will imply that that can be done for the microphone on the table. If your client does need to write things down, so that way nothing is being given away, that might be the easiest way for that to be handled, but that requires the microphone. The seating set up in the gallery, I believe the first two rows behind the defense, those are not going to be available to any members of the media. As far as the font size of your computer, if you need to rearrange how you're seated at the table, so if you need a seat on the far left, or my right, your left, so that way your computer can face the wall and no one can see it. I don't really know what I can accommodate you with as far as that font size beyond that.
Well, the problem is the end of the table it's not open. It's the leg of the table. So I don't know if we can add a little something, another table that is the same size.
Well, I've tried a 3 co-defendant first-degree murder trial in this room before, and what we had done was one table was between the column and the bailiff's box. There was a table here and then this table here. I think that if we could put a table to our left, that might be one way of accommodating this need.
Right. Please make a request, then the court admin, we will figure out the best way to try to configure the tables. Ultimately, for what needs to
Thank you
come
to the
in with, I believe the state is going to try to, needs to bring in its equipment, audio equipment.
Yes, Your Honor.
All right. Because of that equipment and how it will need to be set up, the tables and how they're configured can't interfere with that. We'll try to accommodate that as best as possible. This comment as to the audio visual needs of the state, other than what has been used before with the audio setup, is there anything that needs to be addressed?
No, sir, it'll be the same setup with the same company.
All right. Probably then they'll need to get started by the 15th in this room so they can set up all equipment, test the equipment, and if there's any problems, we'll be able to figure out what needs to take place before we actually get started on the 19th.
This means I'm going to,
All right.
before I
For
travel to the States,
media presence, that will be
you don't know, my flight is on the September 3rd, which means I can cover this trial, but on the 3rd and maybe a bit on the 4th, might be a bit behind. 4th to 5th, I'm staying at a hotel, which means hopefully I have Wi-Fi. Then I'm going to be in a camper van. Then I have to rely on AT&T's tourist, what it's called, the tourist free internet thing if I'm going to stream this. So we'll be traveling around Utah from September 4th to September 18th. Going to visit some of the national parks and stuff like that. I can't buy Starlink for just 2 weeks in Utah. That's a bit too much money for me. But I will do my best. I mean, I covered the Kate trial. I covered the Charlie Adelson trial, and I will cover this trial. Am I coming in near Indiana? Nope. No, JMR, I will not do roaming. No roaming. I will be in Miami, 18th to 24th. 18th to 24th. Me and Steve Gosniak are going to have a meetup. Which national park am I going to? I have bought a pass for all of them. Oh, I will be driving around in a camper van, and then I'm going to try to see a bunch of these old Western movie sets and stuff like that. Roaming is what do you call out-of-network cell coverage? Well, yeah, but we do too, but roaming has another word here. It's holy fuck, who put this on my bill? So roaming it's just another word for expensive over here.
Here as well, I believe it would be similar rules as it's been in the past. There will be one live video camera, there will be one still frame camera. Obviously, the bloggers and reporters, they are permitted to take notes as if they were print journalists. But the initial rows behind the state, as Captain, I assume the victim's family is wishing to appear.
Yes, Your Honor.
They will receive priority seating.
I wonder if Wendy's family will be behind her. Oh no, they are in prison. And Wendy is a witness. Maybe Harvey, but he only needs a child's share because he's really, really tiny.
To have a position in the gallery. After that, it will be free to the public and the press to seat in all areas that are available. Does other party need to be heard concerning those?
Your Honor, we're also going to need space for our client's family and friends who are going to be
Friends?
to support her as well. We would request that they have
Yeah.
priority seating as the victim's family.
That's what the two rows will be behind the defense that will be available to family and friends. Again, similar to the last trial, other than the video recording and still frame photography recording, beyond that, no cell phones are to be out recording any other matters or trying to take photos of the witnesses or the jurors. I believe similar in the last trial when Special Agent Jimenez testified, his face was not shown, obviously because of the nature of his past work. The court will just make the same ruling concerning that as well. His face is not to be shown, but of course the substance of his testimony certainly may be reported on by anyone who believes it is newsworthy. During the selection of the jury, the faces of the prospective jurors are not to be shown. Their names are not to be shared. But as far as any biographical type data, such as the composition of the jury, being, for example, 7 male, 5 female, what their professions are, those are certainly able to be reported on by the members of the media and disseminated. But ultimately, what I'm getting at is names and faces, so we don't have any disruption or disturbance during the trial. Do any of the parties have any questions concerning those?
No, Your Honor.
There you are. One last thing, typically, I don't think I've had a trial with you quite some time. Typically, my paralegal sits with us, so that's another reason why we need that additional table. She also may have some additional people assisting her, and I'll make sure that they're identified as the bailiffs so that there are no issues there.
The members of the direct support staffs may sit on the benches that are behind the attorneys, or if we need to figure out a table configuration for them, if we have the space. But the direct support staff is permitted as to both sides. Does either party have anything further to raise? concerning the logistics of the trial or any other issues before we finish?
No, Your Honor.
There you are. One other matter comes to mind if the attorneys can briefly approach.
Okay. Don't know the reason for the approach, but here they are back. It's a rental. I'm going to be in a rental camper van. I'm not going to build something with a Coke can, metal coat hangers, and DVDs.
We will be in recess for today. The jury selection will start August 19th at 8:30 in the morning after the initial group of jurors has been qualified. From there, we will move into the pre-screen process as previously discussed. Have a good day, everyone.
Thank you, Judge.
All right. I mean, it seems like this trial will be much shorter than Charlie's trial. Mainly because this set of defense attorneys got a bunch of things excluded, including things that were in the divorce material and the custody. They are more or less only allowed to use it as demonstrative. And that was, I mean, a few days of testimony last time. So defense is definitely doing better this time around getting things excluded. Which means that, all right. Which tells us that this judge is an actual gatekeeper. He listens to the defense argument and the prosecution's argument and makes a decision out of that. Because if the defense doesn't bring up correct case law, then they're screwed. So it seems like this set of attorneys is doing a better job. But okay, so we are aiming for, because I don't really care about the jury selection and stuff like that. I don't know if they're even going to stream it. But we're aiming for August 19th. Tuesday, August 19th. They're beginning the jury selection 15 and hope to be started August 19 at 8:30 in the morning. That will be the aim for my coverage as well, if I can be back from work that early, because that would be 8:30 would be 2:30 p.m. my time, which also means I now have not that many days to get up to speed in the Delphi case and some more of the Laura Owens case. So in about 2 hours, we are going to talk not about the Delphi case. We are going to talk about Michael Fosler in the Aaron Spencer case. One of his earliest victims, Michael Fosler's, from 1981, has come forward. And we are going to listen to her story. Folks, I hope to everything that's holy that her story gets more of his victims to come forward. Because He was 24 at the time, she was 15, and the babysitter. And a bit of a spoiler, according to this person, this woman, his wife was in the bedroom when he assaulted her. Yeah, so we will go through that at noon Eastern time in about 2 hours. I'm going to redirect you to that stream. Hold on. Dun dun dun. Dun dun dun. So you can put your thumbs up and notification on that stream. But that is what I had for you. I mean, I don't think, even with these tiny wins from the defense, that Donna can avoid getting what's coming to her. But you never know. This is a much better set of attorneys than Charlie had. So you never know. It will be an interesting trial. It will be very, very interesting, starting August 19th. All right, folks. Thank you for being here. Thank you for allowing me to do this. And I will see you back here in just under 2 hours. Okay? See ya. Bye-bye. Oh, outro. I'll play the intro one more time.
Sail the raven waves, brothers, axes high, shields strong. From distant lands we gather, hearts of fire all along. Oh, big Nick calls we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big because we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. From horizons wild we roam, with thunder in our soul. Every battle brings us home to the stories ages told. Oh, big Nick calls we follow, through the storm